We're now going to look at termination of tenancies. This can be a complex area, and as such it has caused agents to have quite a number of sleepless nights. However, the principle is fairly straightforward. First of all, nothing in a tenancy agreement can override a statutory right, and the Housing Act contains statutory rights that tenants and landlords must comply with. So, as such, if the law requires one thing and a contract requires something else, the law takes precedent and the contractual clause will be unenforceable. First of all, either party can terminate an assured short-hold tenancy at the end of the fixed term. If the tenant decides they wish to terminate the tenancy at the end of the fixed term, no notice is required. They simply need to inform you and/or the landlord that the tenancy will conclude on the end date of the fixed term. Often, agents request that a tenant gives a month's notice, and some write it into the tenancy agreement. But as I outlined previously, this is not enforceable. If a fixed term tenancy is due to end on the 31st of the month, the tenant need only inform you the day before, and they must be released from the tenancy on the 31st of the month. Where the fixed term has ended, and the tenancy is now a statutory periodic tenancy, the tenant is required to give formal written notice if they want to terminate the tenancy. This is a statutory obligation and the tenants must comply with it. The notice must be a minimum of one tenancy period, and the tenancy must end on the final day of a tenancy period. Tenancy periods are usually a month and in line with the rental payment days. Tenancies therefore must end the day before the rent is due, and the notice must have been given at least 1 month before that end date. If the landlord wants to end an AST at the end of the fixed term, they must give a minimum of 2 months written notice. Again, the Housing Act dictates this and it must take place. So the written notice can be sent on any date, providing it is at least 2 months prior to the end date of the fixed term. It isn't a prescribed notice that is required. It simply needs to be in writing, outlining the fact that the tenancy will end at the end of the fixed term. If the landlord wants to end a statutory periodic tenancy, the Housing Act requires them again to give a minimum of 2 months written notice. Again, the tenancy must end at the end of a tenancy period, usually will be in line with the rent payment periods, so the tenancy will then end the day before the rent is due. Again, it isn't a prescribed notice, simply needs to be in writing outlining the fact that the tenancy will end on a particular date. There are times when a landlord would like to end a tenancy during the fixed term. Now, there must be good reasons for wanting to end during the fixed term, because possession can only be obtained if the tenant has breached one or more of the 17 grounds for possession set out in the Housing Act. It might be that the tenant is causing a nuisance, or has damaged the property, or is in rent arrears. In these cases, you can issue a notice known as a Section 21 notice, and this notice is a prescribed notice and it must be completed exactly as laid out in the Housing Act. Again, normally this is done by an experienced solicitor to ensure no errors are made that could allow the tenant to avoid termination. We've only talked about ASTs so far, so I'm now going to cover contractual tenancies. So these tenancies are not protected by the Housing Act, and the requirements to end that tenancy are therefore more relaxed. For a fixed term contractual tenancy, the landlord need not give any notice to terminate the contract at the end of the fixed term. It will simply end unless there's an agreement to extend it, and then it may well become periodic. Tenancies end in this matter due to what is known as effluxion of time. Don't assume your tenant will be aware of this. Contact them sometime beforehand to go through the checkout procedures and give them information about how things will happen. As this contractual tenancy is not protected by the Housing Act, the 17 grounds for possession don't apply. Therefore, if the landlord wishes to terminate the tenancy within the fixed term, it will only be possible if the tenant is in breach of contract. This means they have to have breached one or more of the specific terms within the tenancy agreement. Make sure you enter specific terms in any contractual tenancy so that everybody is very clear about that and gives you the opportunity to issue proceedings if necessary. For example, it may be failure to pay rent, may be causing damage to the property. These will all be outlined in the tenancy agreement, and the landlord can then issue proceedings through the county court, applying for a remedy that they require. It may be an order for possession, compensation, or both. A contractual tenancy can become a periodic contractual tenancy in the same way an AST does. If a landlord wishes to terminate such a tenancy, he must serve a written notice to quit, which can be in any format, but it must contain the prescribed information shown here. Where the landlord or the tenant wishes to terminate, then the required minimum period of notice that applies to the tenancy is whichever of the three of these apply. So it will either be 4 weeks, one period of the tenancy, which would tend to be a month, or the notice period which is stated in the tenancy if there is one. The same rules concerning the end date of a tenancy apply, and so the tenancy must end the day before the rent is due. We'll now look at assured tenancies. Now, these provide the tenant with considerable rights to remain in the property. These tenancies have no fixed term, and so obtaining possession is particularly difficult. If the tenancy is an assured tenancy created under the Housing Act, then the landlord will only be able to bring it to an end using a notice under Section 8 of the Housing Act stating the grounds for possession that apply. If there are no applicable grounds, then the landlord will not be able to obtain possession.